More than half of the country is telling the Supreme Court that the lower courts are making a mockery of Heller and Bruen in order to uphold magazine bans, and they're asking the Supreme Court to step in and stop it once and for all. Imagine this. At least half of all American gun owners here in this country, millions upon millions of law-abiding citizens, own what's called a standard capacity magazine that'll hold more than 10 rounds. Now, they're not exotic. They're not even rare. They're the everyday tools of self-defense, sport shooting, and hunting. But in Washington state, actually in 14 states, those very same magazines are outlawed, and the Washington State Supreme Court just upheld that ban. Now, 26 states have banded together, filing a powerful brief urging the United States Supreme Court to step in and restore the Second Amendment protections once and for all. Folks, this case could be massive for the future of our Second Amendment rights here. But before I dive in, I want to thank today's sponsor, Blackout Coffee. Patriots, if you love America and you love your coffee strong, you've got to check out Blackout Coffee. We are not your average store-bought brand. Our stuff is premium, small batch roasted, made right here in the USA by people who love freedoms as much as you do. Now, every single bag is roasted fresh, so you're not getting coffee that's been sitting on shelves for weeks or months. You're getting bold, rich flavor delivered straight to your door. And when you support Blackout Coffee, you are supporting a company that proudly backs the Constitution, sends money to Second Amendment groups so they can sue the government, and we support hardworking Americans. So start your mornings the right way with coffee that tastes as good as freedom feels. Head on over to blackoutcoffee.com and use my code GNG10 to save 10% on your order. Blackout Coffee, wake up like a patriot. All right, let's get into this brief because it's one of the strongest pushes yet against the wave of unconstitutional magazine bans popping up around the country. Now, this case is Gator's Custom Guns versus Washington, and the Washington State Supreme Court upheld the state's ban on magazines holding more than 10 rounds. Now, they did so by claiming that these magazines are not arms under the Second Amendment, and even if they are, they aren't commonly used for self-defense. We're seeing that a lot lately, but that is not a requirement seen anywhere in the Bill of Rights. Now, think about that for a second. The court admits that there are between 30 million and 159 million of these magazines in circulation, but they then turn around and say that they don't qualify for protection. That's legal gymnastics at its worst. Now, Montana and Idaho led the charge, joined by 24 other states and even the Arizona state legislature. I know, Jared, what states are they? Here we go. Like I said, the states of Montana and Idaho were joined by Alabama, Alaska, Arkansas, Florida, Georgia, Iowa, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, Wyoming as well. They all joined the amicus brief to safeguard citizens' constitutional rights to keep and bear arms against unnecessary intrusions. And that right includes the right to possess and use essential components of modern arms like 10-round plus magazines. These states are urging the Supreme Court to grant certiorari and reverse this BS decision. Now, the message is clear here. This isn't just about Washington state, it's about rogue courts across the country flat out defying the Supreme Court's rulings in Heller and Bruen. These states argue that only the Supreme Court itself can stop the lower courts from watering down the Second Amendment. The states point out that courts in anti-gun jurisdictions are actively twisting the Supreme Court's words. Instead of following the Bruen test, which requires government to justify a gun law with historical tradition, these courts are inventing their own rules, like commonly used for self-defense. For example, the Fourth Circuit said that AR-15s are not really arms at all. The Seventh Circuit claimed that AR-15s are basically M16s and can be banned. The First Circuit said that popularity doesn't matter, only usefulness for self-defense. Now, each of these rulings ignores what the Supreme Court has already made clear. If something is commonly possessed by law-abiding citizens for lawful purposes, it cannot be banned. And the Washington Supreme Court tried to dodge this issue by saying magazines are just accessories, not arms. But the states fire back hard here. A firearm without a magazine is like a car without a gas tank. Sure, technically you could put one round in the chamber and fire the gun, but it destroys the firearm's function. Magazines are an essential component of nearly every modern repeating firearm. To say that they're not protected is like saying the First Amendment protects newspapers, but not the ink or the paper. This one is simple. they're everywhere. Studies show that 48% of gun owners have magazines over 10 rounds. And Americans own an estimated 542 million of them. I don't know how they guesstimate that because I ain't telling you how many I have. The popular handguns like, say, the Glock 17, they ship with 17-round mags. Rifles, like the AR-15, 30-round mags. These are not large capacity, they're standard capacity. And remember, the Supreme Court in Gator versus Massachusetts unanimously ruled that stun guns were protected even though there were about 200,000 people who own them. If that's common use, then hundreds of millions of magazines definitely qualifies. Bruen requires states to show their modern gun laws are consistent with historical traditions. Washington tried to compare its ban to things like trap gun laws, gunpowder storage laws, and Bowie knife restrictions. But none of these are even remotely similar. Trap guns are not bearable arms at all, they're booby traps. Gunpowder laws were about fire safety, not disarming people, and Bowie knife laws came after the Second Amendment, and it didn't ban possession, it just was stupid, and those have been overturned in most places as well. Bottom line, the state of Washington could not come up with a simple, relevant historical example to justify the ban. Now, this isn't just about Washington. Right now, courts in Illinois, Rhode Island, Massachusetts, and California have already upheld similar bans. And the message from these states is clear. Unless the Supreme Court steps in, millions of Americans will lose access to constitutionally protected arms based solely on where they live. Now, these 26 states are asking the Supreme Court to take the case, reverse the Washington ruling, and finally settle the magazine ban issue once and for all. The brief lays it out plainly. Magazines are arms. They're in common use, and they have no historical basis for being banned. Washington's decision isn't just a bad law, it's a direct attack on the Second Amendment. Now it's up to the Supreme Court. Will they take the case and put an end to the patchwork of unconstitutional bans? Or will they let hostile states and rogue activist judges continue to chip away at our rights? I'll be following this case every step of the way, and you can count on me to keep you updated. Answer those questions for me down below. And if you value the Second Amendment and want to stay ahead of the curve on this case and others just like it, make sure you hit the subscribe button and ring the bell notification. Drop a comment down below. Do you think the SCOTUS will finally take the case, or will they keep punting like they have with other challenges? Let me know what you guys and gals think. Until then, stay safe, stay free. I love you, America. God bless you. Take care.